Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, would anything have changed? The use of the failing firm defense. Many times when there are mergers between competitors or that may raise competitive issues, regulators will consider arguments that the merger is necessary because without the merger, one of the firms will go out of business. And this can be a very compelling point. After all, a merger that may have some competitive concerns coming with it seems a better alternative than losing that competitor, losing that marketplace participant altogether. What practitioners call the failing firm defense can be a slippery slope, though. And regulators have historically looked at the defense askance. But in today's economic conditions, the failing firm defense may become more and more important. We have two experts that are going to join us today, one from Europe and one from the United States, who are going to discuss this defense and also and explain it to us in the context of the pandemic and the economic downturn and what that might mean to how the defense is considered. My host today is Matthew Hall. Hi, Matthew.
Hi, John. It's good to be back.
Matthew, what are we doing today?
As you said, John, we're going to be looking at the failing firm defense in merger control. The regulators in those cases asked to consider, does the transaction make any difference to the competitive situation that would have existed otherwise? It's always there as an argument. But as you mentioned, the COVID crisis and its aftermath has really brought it to the fore. There's updated guidance which has come out. And we have the general issue of should it be applied more flexibly during an economic downturn. So Courtney and Nick are going to talk to us about how it works, the practical issues, and the impact of the pandemic.
All right, so who are our guests? Who are Courtney and Nick?
Well, we have Courtney Dyer from the law firm Overy in Washington, D.C. Her practice focuses on U.S. government merger and non-merger investigations, private antitrust litigation, and counseling clients on antitrust issues. Hello, Courtney.
Hi, thanks for having me today.
And we have Nicholas Levy of the law firm Cleary, Gottlieb. Nick focuses on EU and UK antitrust law. He has extensive experience notifying mergers and JVs under the EU merger regulation, coordinating the notification of international transactions, and advising on all aspects of EU and UK antitrust law. He works in London and Brussels. Hello, Nick.
Hi, Matthew.
Courtney and Nick, thank you very much for joining us today. I thought we would start with just a bit of a historical perspective and looking back over the years of some successful cases when the failing firm defense has been used in the US and in the EU. Courtney, could you just take us through a couple of examples which the listeners may have heard of from the US side?
Sure. Just to give you a little bit of background in the U.S., you've got the failing firm defense, which is a defense that's the agencies have described in the horizontal merger guidelines that if the elements of the defense are met and otherwise potentially anti-competitive transaction might get a pass and cleared under the antitrust laws. Courts have applied similar factors when looking at it in a litigation context. And there's also what they call the flailing firm defense, and we can talk about this in more detail if we need to on the call, but that's a defense where the elements aren't met, that there's some of the factors that the parties aren't able to completely satisfy, yet the companies in the transaction or the target company in the transaction is a weakened competitor. So the market shares aren't necessarily reflective of the competitive significance of that company in the market. And so when I when you asked about an example, one that recently comes to mind, the courts did look at the elements of the failing firm defense, I think ultimately concluding that the target company was a weakened competitor, and that factored in to the many factors that considered in allowing the transaction to proceed. And that's the Sprint T-Mobile transaction. And I know that was the subject of a podcast on this, I don't even know what to call it, on this channel in this podcast world. And it was a very good one. And there, where the states had continued to litigate that transaction after the DOJ settled it with the parties. And the defendants argued that Sprint's financial condition was poor, and it didn't have the ability to make the meaningful investments necessary to run a successful network. So their lack of long-term sustainable strategies and their ability to continue as a true national mobile network, the court found compelling that they weren't in a good position to do that. They had a lot of layoffs, which hampered their customer service. They had limited ability to secure debt financing. There was no prospects of a purchase from another less competitive entity. So the judge in that case did cite their poor financial outlook as partial reason to dismiss the state's antitrust suit. Their financial condition made it less likely for them to invest in the network upgrades. They were losing millions and millions of customers per year, and that the lack of sustainable long-term competitive strategy made the judge feel strongly that they wouldn't be a truly national network going forward. So the fact that there was no other kind of prospective purchaser that would allow them to continue in the market with, I guess, less anti-competitive concerns. And the fact that they thought that the plaintiff's picture of what the competitive landscape looked like was overstated in light of Sprint's kind of fledgling financial condition.
So a great recent example from the US there. And thank you for promoting another of our Curious Amalgam podcasts at the same time. And as you mentioned, and we'll talk about this a bit later, there is, if you like, the true failing firm defense and the more nuanced kind of flailing firm where you're not fully within those bounds. But we can talk about that a bit later. Nick, on the EU and the UK side, I was looking a bit back, and I think the first true failing firm defense case dates from in the early 90s in the EU, and there haven't been a huge number since then, but maybe you could talk about a couple of the old examples and just to give us some of the background as well.
Well, that's right, Matthew. Thank you very much. Delighted to be here today. This is obviously a very interesting topical topic. As you said, the failing firm defense has been available in the EU for a long time. It was first acknowledged a few years after the merger regulation came into force in 1990. It's one of two defenses available, the other concerning efficiencies and the ability of companies to identify countervailing merger-specific efficiencies. It's worth mentioning that both the failing firm defense and the efficiencies defense are only available, as you said at the beginning, where the agency, whether it's the Commission or one of the national agencies in Europe, has already identified a significant anti-competitive effect, harm likely to arise from a given concentration. And therefore, it's perhaps not surprising the defense has been accepted only rarely. I think almost count on the fingers of one hand, maybe you just get to two, the number of cases where the failing firm defense or some variant of it has been accepted by the European Commission. And unsurprisingly, I think, in light of the circumstance that it's only available rarely, the agencies have made clear that the burden of demonstrating the requisite elements of the defense rest firmly on the parties. Notwithstanding the fairly exacting criteria and the strict application, there has been an evolution in the circumstances in which the defense may be available, and that's involved some relaxation of the criteria since the first occasion when the defense was recognized back in 1993 in a case involving a company called Carley and Saltz, shortly after the regulation came into force. And the criteria have been relaxed in a couple of respects. Firstly, the Commission no longer requires evidence that a failing firm would exit the market. It's sufficient to show that it would be closed down. Also, the Commission no longer required that all of the failing firm's business would be obtained by the acquirer in the absence of the transaction. It's sufficient to show that the assets to be acquired would inevitably exit the market if they weren't taken over by another undertaking, and that the effect on the market would be no worse if the transaction were approved than if it were prohibited. So where are we now after this jurisprudence, which, as I say, is not extensive, but has nonetheless evolved the criteria? There are three criteria. The first two are critically fact-based, and the third involves some appreciation. The first two criteria are as follows. The allegedly failing firm would in the near future be forced out of business, either it exits or it closes because of financial difficulties unless it were acquired. So it's truly a failing firm, or as Courtney said, a failing division, a flailing firm perhaps. Secondly, there must be no less anti-competitive alternative purchaser than the proposed acquirer. That's really a fact-intensive inquiry. And thirdly, the effect on competition would be no worse if the transaction were to be approved, since in the absence of the merger, the assets of the failing firm would inevitably exit. So you asked Matthew for a good case. There's not a huge number to choose from, as I said. I think perhaps the best case, maybe the cleanest case, was a case involving an oil refinery in Hamburg, Germany, that was owned by Shell. Shell was planning to close that refinery. Of course, there was no question of Shell being forced out of the market due to financial difficulties, as the company was in a healthy position and could, if need be, have supported the refinery. But internal documents and financial data and so forth convinced the Commission that this refinery, which had been loss-making for several years, was likely to remain unprofitable in the future and would therefore be closed irrespective of the transaction. And the Commission then, as I say, determined the counterfactual would likely have been closure. Second question then, was there a less anti-competitive alternative purchaser to Nynas? The Commission found that they were the only companies seriously interested in acquiring the business. They looked at a possible acquisition by a US company called Ergun, but they determined that Ergun was not a likely buyer. They looked at the plant in the past, failed to reach agreement with Shell. They initially manifested an interest during the investigation, but subsequently declined. And the Commission determined that should the Commission prohibit the acquisition by Nynas of the refinery, Ergun probably wouldn't have an incentive to acquire the refinery, since its principal objective, namely taking out capacity and ensuring that Nynas, its main rival, would be capacity constrained, would have been achieved. And then the final thing the Commission looked at was whether the counterfactual, so what would have occurred in the absence of the transaction. And there they determined Shell would have closed the refinery, the assets would have exited the market, thereby causing production capacity to be reduced and prices to rise. And so the continued operation of the refinery was not a realistic counterfactual to the transaction.
So that's an interesting case, Nick, as you say. It was one part of a business, so that was really a type of failing division defense, wasn't it? It wasn't the full business that was going out of or arguably going out of business there. It was part of it, so it's a division. You mentioned this being a defense at one point, and other points you're referring to this as the counterfactual. Counterfactual is, of course, a term of art which is used throughout antitrust law in all aspects, not only merger control. Could you just briefly, Nick, just describe to us how you distinguish this defense and this concept of a counterfactual in this context, or are you really talking about the same thing?
I think the way I think about it is that the defense is a particularly extreme counterfactual. So the counterfactual is obviously requires an assessment of the market structure, dynamics, competitive performance in the absence of the merger. So in assessing any given merger, you ask yourself, as a practitioner, as an enforcer, what would the world look like if the transaction didn't go ahead? And the most extreme counterfactual to the merger could be the complete disappearance of one of the parties to the merger. So in thinking about the advocacy that one develops in a given case, describing and evidencing the counterfactual has always been a part of the inquiry that one engages in, because the agency is going to engage in it, but has become an increasingly important one. And one of the reasons for that is the increased focus, particularly over the last 10 or 15 years since the merger regulation substantive test was changed to one that focuses on the competition that will be lost as a result of the transaction. That's led to a particular focus on the counterfactual and on the competitive dynamic between the merging companies. And therefore trying to understand the competitive strength of both the acquirer and the target is part of that inquiry. And sometimes that leads you to determine that you have a failing firm defense available. To some extent, that's kind of a last resort, because you've conceded that there may be some sort of anti-competitive harm.
Absolutely. I mean, as you say, the counterfactual, the normal counterfactual in absence of any other factors would normally be that the target is the status quo, isn't it? That's what it would stay in business. But this is a type of different analysis of what would happen. Courtney, Nick was mentioning 3 specific criteria which have changed over time. These actually appear in the EU's own guidelines in some form. Is there a similar situation in the US in terms of it being set out? I mean, you mentioned a bit earlier, but it set out so clearly in guidelines, or are we relying purely on case law for the particular specific criteria we need to prove?
Yeah, they are laid out in the horizontal merger guidelines that the DOJ, Antitrust Division, and the FTC have published. So there are 3 factors that are enumerated rather clearly in those guidelines. And just to kind of rehash, though, they're similar to the ones that Nick mentioned. The first element is that the firm is unable to meet financial obligations in short order. And that's a test of looking at whether the firm's liabilities are greater than their assets, their costs are greater than their revenues over a particular period of time. And you would distinguish the inability to meet financial obligations from a company that's simply in need of new management or new business strategy. So it's a pretty high element to meet. The second one is that the firm can't reorganize successfully in bankruptcy. So if they can eliminate their debt, it wouldn't be enough to continue as a viable operation going forward. So they can't reorganize if they can't meet current or expected operating expenses. And the third prong, similarly to what Nick was saying, is that the firm had made good faith efforts to find an alternative purchaser with less antitrust risk, but those efforts were unsuccessful. This is a hard element to meet at this test as well. Any offer above liquidation value is considered an alternative transaction. So the parties really need to show they've made a good faith effort to solicit a number and variety of buyers, both financial and strategic ones. And that will depend on the size of the market as to what's the proper scope. But they have to make good faith efforts to find a less anti-competitive alternative. Like I said earlier, the courts have generally made have required parties to make similar showing. There's there's imminent danger of failure, no chance of successful reorganization, and no alternative purchaser. And these elements in the failing division defense are the same, even if it's an otherwise healthy company. If they've got a division that meets those three criteria, then they can use it in that context as well.
Right. So, like much else in merger control, apart from on the substantive side, at least, there seem to be quite strong parallels here between the US and the EU situations. John mentioned, of course, we had the COVID pandemic, which, needless to say, has had some significant impacts on a large number of business areas. Nick, have we seen any cases in the EU or the UK where we've already seen the failing firm arguments coming into play on the merger side?
So yes, we have. But firstly, just a general comment as to the agency's thinking as to the implications of the pandemic. Both the European Commission and the CMA in the UK obviously recognise that the pandemic has had and is going to continue to have a fairly profound effect on the majority of the world's companies. It's going to affect demand and supply in different ways in different industries, and the midterm challenge is going to be to determine whether those changes are permanent or transitory, and to distinguish between those scenarios. Both agencies, though, have come out with statements effectively saying that they're not going to relax the existing standards. Commissioner Vestager in April of this year excluded a more permissive approach and warned that the crisis shouldn't be a shield to allow mergers that would hurt consumers and hold back the recovery. And the CMA in the UK had made similar statements that the pandemic has not brought about any relaxation of the standards. There's an interesting case in the UK involving a minority investment by Amazon in a food delivery company, Deliveroo, a bit like a Uber Eats kind of service. And that was a somewhat controversial transaction because there was a question as to whether the agency had jurisdiction over it at all, but they took the view that they did. And one of the questions in that case was whether Amazon would have developed a competing service in the absence of its investment. But there was also a series of submissions made about Deliveroo's future. And the CMA in April, when the pandemic was obviously beginning to break, or at its early stages, but fairly intense period in Europe, they took a view that Deliveroo's situation as a result of the crisis, they took the view that Deliveroo was likely to exit the market, and that the loss of Deliveroo as a competitor would be more detrimental to competition and to consumers than permitting the Amazon investment to proceed. So the provisional view back in April was that the conditions for the failing firm defense were met. 2 months later, somewhat extraordinarily, they changed tack. They revised their view and came out with a new provisional view, which determined that in light of the success that Deliveroo had during the pandemic, that it was unlikely to exit the market, but they nonetheless concluded that competitive harm wouldn't arise from the transaction. So it has mixed messages, I think, as to the way in which the crisis may affect agencies' thinking. I suspect what it's going to mean is that all things equal, agencies may prefer either to find some other reason to approve a transaction involving a failing company, or to have a bit of distance from the pandemic before taking a view on whether the changes or the market situation one observes is permanent or temporary.
Yeah, that's probably right. And as you say, Nick, things were, I guess, part of the problem in that Amazon case, which was only a 16% investment. So we could probably have a whole different podcast on the kind of minority interests, whether it should be looked at. But I guess things were moving so quickly with the pandemic that it was difficult for them really to get a hold on what was happening with Deliveroo there. Courtney, what about in the US? Have we seen the pandemic? Have we seen guidance, as Nick was mentioning, from the regulators in the EU, similar to what regulators have had from the EU? And have we seen cases where the issue has already appeared?
Yes, I think similarly to what Nick was mentioning, the agencies here in the U.S. have both come out and said that their scrutiny of anti-competitive transactions are not going to be relaxed in light of the pandemic or the economic conditions caused by that, and specifically stating that the antitrust laws that we have in the United States are flexible enough to adapt to these changing market conditions. And that is consistent with past agency leadership during economic crises in the past, where they haven't loosened the requirements, particularly of this defense, even though they've recognized that general economic conditions might be relevant to the merger review. I think they've both made clear that legal standards are going to stay the same, but that these economic conditions may, impact the ability to use these defenses. And there has been a case that came out this year in the dairy industry, and there was two separate transactions. One, the bankrupt company, or the company in bankruptcy, was Dean Foods Company, and they were trying to sell plants sell their assets out of bankruptcy to competitors. And one of the transactions was a company called Prairie Farms Dairy that was going to buy some of the fluid milk processing plants from the bankrupt Dean Foods. It was not a reportable transaction given the transaction value, but the DOJ nonetheless took a look at it, but they concluded that the plants at issue here, the assets or the division, would likely be shut down if it's not purchased by the Prairie Farms because of the distressed financial condition of Dean Foods, and that there were no other alternative operator who could timely buy the plants. And this is one where the geographic scope is rather localized. These are processing plants that deliver milk, for example, to restaurants and schools. And so this collapse in milk demand caused by schools shutting down and restaurants shutting down because of COVID had really decreased the demand. And so time was really important to get these assets in the hand of someone that could continue them in the market. There was a separate related investigation with Dairy Farmers of America, who was also buying some assets from the bankrupt company as well in other geographic regions. The DOJ did require it to divest some of those plants before it could complete its acquisition, because it found that even though these assets potentially could exit the market, it wasn't. They didn't feel as if the likelihood of the exit of the market was something that couldn't be solved through a divestiture to another buyer, that there was an alternative buyer out there that could keep these assets in the market. So they allowed DFA to continue to make the majority of its acquisition, but it had to divest 3 plants before it could complete the transaction. So COVID-19 didn't alter the DOJ's approach or the analysis to how it looked at the failing firm or the failing division or failing assets defense. But it did, Assistant Attorney General Macon Delorham did say the dire financial straits of Dean Foods and the impact that the pandemic had on the milk industry required a very fast but comprehensive investigation. So while the legal standard was the same, I think the speed at which the DOJ reviewed this transaction was definitely stepped up during the pandemic.
Okay, so some interesting cases there. As an aside, I think it's interesting in the EU to see how the state aid rules have been so relaxed during the crisis, but as Nick was saying, the merger rules and the failing firm defense apparently stay the same. Just before we get to the personal questions at the end of our podcast, Nick and Courtney, if you think about practical tips for our listeners on how to manage these types of processes, if you could just quickly give us 2 or 3 of your key tips from an expert practitioner point of view on these types of cases. Nick, would you mind starting from your point of view?
So the critical advice here, which is common to questions that arise in all sorts of areas of antitrust is that the evidence has to be compelling. You have to have compelling evidence as to the highly challenging financial situation of the target, which in a case where you're representing the buyer, you have to go to extra lengths to try to verify that evidence, and you have to have compelling evidence that every effort has been made to find an alternative purchaser. And there's an interesting recent case from last year where the companies didn't run the failing firm defense, but they did provide extensive evidence of the weak and deteriorating competitive performance. This was of a Dutch telecommunications company, and that evidence was, highly probative in persuading the commission to approve the transaction. So the facts are critical. You've got to have as much evidence as you possibly can, and if you get tripped up, clearly your credibility is going to be affected.
Thank you. So there we have another example of not a full failing firm, but some other type of counterfactual, I think. And Courtney, just to finish us off, what are your key practice tips as you see them?
Yeah, I think they're similar to Nick's. I think the economic conditions that were presented here today by COVID-19 means that there's probably a greater potential for companies to meet the standards of the defense, not because the standards are lowered as we discussed, but because more firms are actually failing and fewer options to keep their assets in the market. So I think one of the elements of this defense that is in the control of the companies is the requirement to make a good faith effort to find alternative purchasers. So my practical tip would not only be to make sure that you do a broad reach of potential acquirers and a variety of types of acquirers. Agencies and courts will look at the transaction agreements themselves. So if there's provisions in the agreement that would hinder those efforts, things like no talk provisions that require exclusivity for negotiations, things like no give provisions that prohibit the exchange of confidential information with potential buyers, no shop provisions that preclude companies from looking at other potential buyers. All of those, are detrimental to being able to successfully meet that prong. So in addition to, again, reaching out to a wide variety of potential buyers, make sure that the agreements that you are negotiating give the target company full flexibility to find alternative purchasers to the extent that they're out there.
Let's shift gears a little bit. Nick, back to you. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
So in thinking about this, I asked my daughter to name a fun fact about me. And her response was, Dad, you're no fun and that's a fact, which didn't help me very much. So my second thought was something that people might not know about me is that my younger son played in the sandpit with our host, Chair Matthew's son, years and years and years ago.
Yes, indeed.
When you say they played in the sandpit, what does that mean?
They were at school together when they were kids, and now they're young men. So
literal sandpit.
It was a literal sandpit. Yes. They were 5 or something like that, weren't they, Matthew?
Yeah, those are the days.
Courtney, what about you? Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Okay, so I was an all-conference basketball player in high school, which I think ordinarily wouldn't be all that interesting, except for anyone who's met me knows that I'm only 5'2". So I think people find that fact a little bit surprising.
And how did you do that?
The programs of the basketball tournaments that I participated in listed me at a height much greater than that. So it was only when they saw me on court did they realize how short I was.
Yeah, and I always list myself as much taller than I am too. I sometimes at conferences and people ask me if I'm standing or sitting. But Courtney, how did you do that? Was that quickness? Was it accuracy? How did you overcome that burden? I
mean, some might argue the fact that I grew up in Delaware might preclude there being lots of stiff competition, but it was speed. It was speed and hustle. I worked probably twice as hard as the ones that could just raise their hand and grab the rebound.
All right. Well, Courtney, let's stick with you. What advice do you have for younger lawyers or students that want to do what you do?
So I did not always know I wanted to be a lawyer, let alone, an antitrust lawyer. And I think, my career path has been evolving since, I went to George Washington at night, didn't really know what I wanted to do and fell in love with antitrust. And then when I became an antitrust lawyer at O'Melveny, I did litigation, I did cartel work, and then I kind of went into the regulatory aspect and really found a place that I like to practice through the merger review and merger control and counseling. So I don't think, anyone needs to know clearly what they want to do in law school or even within a particular substantive area, what they might find most interesting. But once you do find your niche and understand kind of what makes you happy to go to work each day, I think it makes a big difference. So keep looking for your passion in a particular legal area, and then allow it to evolve as your interests evolve too.
Good advice. Nick, how about you? What advice do you have for students or younger lawyers that want to do what you do?
So the first thing I think to ask yourself is, are you curious about the world? Are you curious about how companies operate, how business operates? Are you interested in economics? Are you interested in advocacy? Are you interested in strategy? Because one of the things that I think is really interesting and enjoyable about antitrust is that it straddles a broad range of areas and requires a broad skill set. In terms of what one might concretely do, learning some economics, I think, is important. Reading widely, and by that I don't mean necessarily only reading legal textbooks, reading about behavioral science, reading novels that are well written, learning how to write well, and developing your skill set as broadly as you can. Spend time with an antitrust lawyer and see if you like what they do.
And there are many antitrust lawyers that you can find in your local sandpit. So that's good advice. With that, let's now turn to our final segment that we call the Curious Hat.
And now it's time for the Curious Hat. In normal times, when we are together, there is an actual hat that has actual questions in it, and I pull a question out of the hat, or the guest pulls a question out of the hat, and we ask that question. Since we're all doing this virtually, I am actually wearing the hat, and I am going to ask the guest to choose a number between 1 and 15, and I will ask the question that corresponds with that number. Nick, why don't you go first? Why don't you choose a number between 1 and 15?
7.
Okay, number 7. Okay. If you could be fluent in a new language tomorrow, what language would that be?
Italian.
Italian. And why is that?
Oh, because it's the greatest country in the world. It's so beautiful. I remember reading somebody say to be born in Italy is to win first prize in the lottery of life. It's so rich in culture and texture, and I just wish I could talk to Italians better than I can.
How about like a made up language? Is there any made up language, Klingon, Dothraki, something like that you would be interested in learning?
I'm so poor at the real languages to try to learn a made-up language will be really hard. The one that Mork in Mork and Mindy used to speak, I don't know what that was. It was probably Mork's language. That was a good language, or it was a good show anyway. I'd love to talk with Mork.
That's a very strong pull, Mork and Mindy. Well done, Nick. Courtney, how about you? Why don't you choose a number between 1 and 15, and we will give you that question.
No, I didn't hear any rules about not being able to choose the same number. So can I also choose 7, or is that cheating?
Okay, 7. Let's see what 7 is. If you could be fluent in a new language tomorrow, what language would that be?
I would choose Spanish.
And why is that?
Because my kids speak Spanish because they've learned in school, and I don't know how to speak it. My husband does a little bit, and I feel like I'm being left out of conversations or being talked about without me really understanding what they're saying.
So for me, Courtney, just to share, I have a similar, mine would be Japanese. Or at least I think it would be Japanese, although I'm not sure about that. My wife is Japanese. And so when I was courting my wife, I would fly to visit her parents in Tokyo, and there would be conversations going on in Japanese that I'm certain were about me. And they would go on and on and on. At the end of the conversation, my wife would say, no, we weren't talking about you at all. Yeah, and I sort of wonder whether I'm better off, if I had known Japanese, would I have been better off? Or is it better off that I just didn't know what they were saying? I don't know if you have a view on that.
My kids are fairly expressive, so I can typically tell when they're not telling me the truth. So even if they claim to not be talking about me, I think I'd be able to tell from body language. But no, I don't like surprises, hence my picking the same number. So I would want to know what they were talking about.
And Courtney, congratulations, because you are actually the first guest to have repeated the number of the prior guests. So that's a good strategy. Well done. And with that, thank you for joining us on Our Curious Amalgam, and we will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.